There's a specific smell that law offices have. Something between old paper and air conditioning that's been running too long. I noticed it the moment I walked in, and I don't know why that's the detail that stayed with me, but it did. I found a seat at the far end of the table, the one nobody had pulled out for me, and I set my envelope down in my lap and just looked around the room for a moment. My cousins were already near the front, talking quietly, comfortable in the way people are when they already know how something ends. A couple of aunts. An uncle I hadn't spoken to in about 3 years, not for any dramatic reason, we had just slowly stopped. Nobody was unkind to me that morning. Nobody was anything to me. That was the part that was hard to explain to people later, when they asked how it felt. It didn't feel like hostility. It felt like absence. Like I was already slightly outside the frame of a photograph everyone else was standing in. I had been erased from this family's story long before that lawyer opened his mouth. I knew that sitting there. And I also knew what was inside that envelope. From the outside, this probably looked like a completely ordinary estate reading. A conference room. A lawyer with a folder. A family that had lost someone and was now working through the administrative reality of what comes after. My grandfather had passed 6 weeks earlier, after a long illness that had taken most of the last 2 years to finish. He was the kind of man who had built things slowly. A property, a small business, a particular idea of what family meant, and who deserved to be part of it. Bloodline was a word he used without any self-consciousness. It meant something to him in a way that felt almost old-fashioned, even when he said it. I had spent years trying to belong to what he built. Not because of what it was worth, but because belonging to it meant something about who I was. I showed up. I helped. I stayed when other people found reasons not to. And I told myself for a long time that those things counted for something. What none of them knew, and what I had only confirmed 3 weeks before that morning, was that the bloodline they were all so certain about protecting wasn't what any of us had been told it was. I want to be careful about how I describe the years before that room, because it's easy to look back and make everything feel like a warning sign. Most of it wasn't. Most of it was just ordinary family life with ordinary friction, and I participated in it willingly because I wanted to. For about 6 years, I was present in the way that some family members are and others aren't. I showed up to things. When my grandfather's health started declining, I was the one coordinating his medical appointments for nearly 2 years. Scheduling, driving, sitting in waiting rooms with him, while other relatives sent text messages asking for updates. One year, when the property taxes came due during a difficult stretch, I covered part of it without being asked and without making anything of it. When a distant cousin passed, I quietly handled a portion of the funeral costs that the family hadn't fully accounted for. These weren't sacrifices I resented at the time. I'm mentioning them now only because of what came later. There were small things I noticed and chose not to examine too closely. An email chain about estate planning that I was never added to, which I found out about indirectly. A comment from one of my aunts said almost warmly that I've thought about many times since, something like, loyalty doesn't always come down to blood. I remember nodding and moving on. I filed it somewhere I didn't have to look at it. About 14 months before that morning in the law office, I ordered a consumer DNA test. Not for any particular reason, I'd been reading about hereditary health conditions and thought it might be useful. The results came back on a Tuesday evening. I was sitting in my kitchen. I opened the app, looked through the ancestry breakdown, and then scrolled to the relative matches. There was a name listed as a close family match, a half-sibling category, that I had never heard in my entire life. I sat with my phone in my hand for a long time. I didn't call anyone. I didn't say anything to anyone. I just closed the app and tried to think clearly about what that meant. The 2 cousins, I'll just call them that, because that's what I believed them to be for most of my life, had a particular kind of ease around my grandfather that I used to interpret as closeness. It took me a long time to understand it was something slightly different. It was certainty. They had been told, in some form or another, probably for years, that the future was going to include them in a specific way. That kind of knowledge changes how you carry yourself in a room. You don't have to fight for anything because you already know the outcome. I don't think they were cruel people. That's the part that's actually harder to explain than if they had been. They were simply operating inside a framework that had never required them to consider whether I belonged in it. When I spent 2 years helping with my grandfather's care, they thanked me genuinely, I believe. But those same conversations never extended to what would happen afterward, and if I ever edged close to that topic, the response was always some version of the same thing, that these matters had already been sorted, that there was nothing to worry about, said in a tone that communicated clearly I wasn't part of the sorting. I started paying closer attention after I found that name in my NA results. Not aggressively. I wasn't building a case at that point. I was just watching more carefully, noticing the patterns I had previously given the benefit of the doubt, and asking myself more honestly what they actually meant. The lawyer read through the preliminaries the way lawyers do, methodically, without inflection, in a way that's probably meant to feel neutral but mostly just feels cold. He described the asset structure, the property holdings, the accounts. Then he began reading the distribution language, and I watched my cousins' names appear in it the way I had already expected them to. They exchanged a look when they were named. Small, quick, the kind of look people share when something they've been anticipating finally arrives. The language that excluded me wasn't dramatic. That's the thing about legal documents. The most significant moments in them are often the quietest. The estate was to be distributed among the biological descendants of the direct line. The executor explained, when he reached that clause, that this specific language had been introduced during a revision to the will made approximately 18 months before my grandfather's death. He said it plainly, as a procedural detail. 18 months prior was about 6 weeks after I had quietly raised, with one family member I thought I could trust, the question of what I had found in my DNA results. I noted that timing. I had already noted it in writing before I walked into that room. Nobody said anything to me directly after the clause was read. The cousins moved almost immediately into practical questions about the property. The room had already shifted into its next phase. One aunt looked at me once, briefly, for just a moment, with an expression I've thought about many times since. It wasn't hostility. It was something closer to relief, which told me more than hostility would have. I reached into my bag. I placed the envelope on the table in front of me. I didn't open it. I just looked at the executor and asked him one question: whether anyone involved in this process had taken steps to verify the biological identity of the named beneficiaries. 5 seconds is a long time when a room has gone completely still. The lawyer looked up from his papers, not with alarm, more like someone who has just registered that the ground beneath a conversation has quietly shifted and is now deciding how to respond professionally. My cousin's expressions changed in a way that was harder to read. The casual confidence didn't disappear exactly. It just hesitated, like a machine that's still running but has detected something it wasn't expecting. The aunt who had looked at me earlier looked away, completely, with a kind of deliberateness that told me the look had meant something. Nobody answered the question. Not immediately. And that silence, those few seconds before anyone recalibrated enough to speak, was the most honest moment in that entire room. Not because it proved guilt. I want to be precise about that. But because it was the specific silence of people who understood that a question had arrived that they couldn't safely answer without first knowing how much I knew. I want to say I felt something like victory in that moment. I didn't. What I actually felt was a grief I hadn't fully anticipated, the particular sadness of having a suspicion confirmed that you had spent a long time hoping was wrong. These were people I had known my whole life. Whatever they had done or hadn't done, that part was still true. I opened the envelope. I slid 2 documents onto the table. The first was a forensic-grade DNA report, chain of custody, laboratory certified, not a consumer kit. The second was a copy of an earlier version of the will. The one from 12 years ago. The one that looked nothing like the document filed for probate. I'll explain what the documents showed as plainly as I can, because the details matter and I don't want to over-dramatize something that was already significant enough on its own. The forensic DNA report had been ordered through a certified laboratory about 3 weeks before that morning. It wasn't the consumer ancestry test that had first flagged the discrepancy. That test had only told me enough to know that something needed closer examination. The certified report was different in kind. It was the kind of document that holds up under legal scrutiny, with chain of custody documentation and laboratory methodology that can be cross-examined. What it showed, stated plainly, was that the shared DNA between my cousins and the patriarch's confirmed biological relatives was not consistent with direct lineal descent. The percentages placed them in a range that geneticists associate with a non-paternity event, meaning somewhere in the generational line, the biological connection that the family had always assumed and built its entire inheritance structure around did not exist in the way everyone believed. I had done enough reading by that point to know this wasn't as rare as people assume. In cases where paternity is formally disputed, studies have found discrepancy rates ranging from 17 to 30%. I wasn't shocked by the finding itself. What had taken longer to absorb was the scope of what had been built on top of it. How many decisions, how many revisions, how many quiet conversations I had never been part of had gone into maintaining a version of the family's biological history that the science didn't support. The second document was simpler to explain, but in some ways harder to sit with. It was a copy of an earlier version of the will, from approximately 12 years prior, that my attorney had located through the original filing records. In that version, my name appeared as a beneficiary, not peripherally, substantively. Somewhere in the years that followed, during a period when my grandfather's health was declining and his world had narrowed considerably, that had changed. My attorney had not used the word forgery. What he had said, carefully, was that the revision timeline contained irregularities that warranted formal examination by the court. One of my cousins asked for a recess. The executor agreed without hesitation, which itself communicated something. They moved into the hallway, both cousins, the aunt, a quiet murmuring I couldn't hear clearly from where I was sitting. I didn't follow them. I stayed at the table with my hands folded in front of me. I had placed what I had on the table. There was nothing left to perform. What came after that morning was not a clean story. I want to be honest about that, because I think people expect these situations to resolve the way they do in films. A dramatic admission, a clear verdict, a moment where the truth lands publicly and everything realigns. That isn't what happened. The probate process was formally challenged by my attorney in the weeks following the meeting. Distributions were paused while the court reviewed the filing. What followed was several months of legal correspondence, document requests, and negotiation that was expensive and slow and emotionally exhausting in a way that the meeting itself hadn't been. There was no courtroom confrontation. There was no moment where my cousins acknowledged anything directly. There were lawyers communicating with lawyers, and eventually a settlement was reached that was private, partial, and came with a non-disclosure agreement that I spent a considerable amount of time thinking about before I signed it. What I received was not everything. I've made my peace with that. It was enough to feel that something had been corrected in the record, even if that correction would never be visible to anyone outside a small circle of people who already knew. The harder and more genuine closure came from a different direction entirely. The half-sibling whose name had first appeared in my consumer DNA results, I had reached out carefully, months earlier, not knowing what to expect. That relationship developed slowly, with appropriate caution on both sides. But it developed, and in that connection, I found something I hadn't anticipated, the specific relief of being in a room where I didn't have to wonder whether I actually belonged in it. I stopped needing the other family to admit what they had done. That need had quietly dissolved somewhere in the process of building something real elsewhere. The truth didn't require their acknowledgement to exist. It had existed the whole time. I had just finally stopped being the only one who knew it.